Good evening and welcome to the 59th Annual National Moot Court Competition, the National Final Round. Over 180 teams started out in this competition back in September. There are 2 left. Those 2 teams are Chicago-Kent and the University of Pennsylvania. Chicago-Kent will be the petitioner. University of Pennsylvania will be the respondent. At this time, I'd like to introduce the participants. From Chicago-Kent, we have Brody Dawson. Brody is from Grosse Pointe, Michigan. She got her undergrad from Davidson College. We also have Andrew Booth from Silver Spring, Maryland. He graduated from Wagner College. Also on the team is Betsy Gates. She hails from Oxford, Ohio, and attended Ohio Wesleyan. On the respondent side, to my left, is Allison Raymond. She hails from Houghton, Michigan, and received her undergrad from Kalamazoo College. Also on the team is Stephen Myers. His hometown is New York, New York, and he went to Williams College. Finally, we have Daniel Schwei of Brookfield, Wisconsin. His undergraduate degree is from Emory University. At this time, I'd like to introduce the panel of judges who will hear argument. We are very pleased to have a very prestigious bench this evening. The Chief Justice is going to be the Honorable Barrington D. Parker, Jr. He is a judge on the United States Court of Appeals for the Second Circuit. He was appointed to the court in 2001 by President Bush. Also on the panel is Judge Shira Shendlin. She is a United States District Court judge in the Southern District of New York. She has been on the bench since 1994 when she was appointed by President Clinton. Also on the bench is Cheryl E. Chambers. She is a New York Supreme Court Appellate Division Second Department judge, and she has served as a justice since 1999, and in 2008 was appointed by Governor Spitzer to the Second Department. Also is Judge John Gleason. He is a United States District Court judge from the Eastern District of New York. He has been on the bench since 1994 and was appointed by President Clinton. We also have Judge Jonathan Lippman. He is currently a justice at the Appellate Division, First Department here in New York. In January, he was appointed by Governor Patterson to serve as the chief judge of the New York Court of Appeals. So he is the chief judge designee of the state of New York. We also have John Jack Dalton. He is the president of the American College of Trial Lawyers, which co-sponsors this competition. He works, he's a partner with Troutman Sanders in Atlanta. And we also have Patricia Hines. She is the president of the Association of the Bar of the City of New York. She is a partner at the law firm of Allen and Overy, and she's also a fellow with the American College of Trial Lawyers. My name is Steve Brower. I am the chair of the Young Lawyers Committee here at the association. It is my privilege to be really the custodian of this competition. Again, now in its 59th year, and I can't tell you how much work goes into this competition and also how proud we are of the caliber of judges we have as well as the caliber of participants. So I will go get the panel and we will commence shortly.
Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
Please be seated. We will proceed with consolidated appeals. Love Your Children Academies and Town of Santa Teresa, consolidated with Cormac T. versus Town of Santa Teresa. Ready for the petitioners, ready for the respondents? Thank you very much. Please proceed.
Mr. Chief Justice, and may it please the Court, I am Andrew Booth from Team 17, and I represent the petitioner, Your Love Children's Academy. I will address the first issue before this Court and show that Section 2 of the Religious Land Use and Institutionalized Persons Act is constitutional, while Betsy Gates, counsel for Petitioner Cormac T., will demonstrate that the Individuals with Disabilities Education Act does not require a child to be enrolled in public school prior to being eligible for tuition reimbursement. At this time, I would like to reserve 2 minutes for rebuttal. Thank you. This case is about Congress using its constitutionally...
Now, you're going to take 15 minutes, is that, 13 minutes?
Your Honor, 15 minutes for myself, 13 minutes for Ms. Gates, and 2 minutes for rebuttal.
2 minutes for rebuttal. Very well.
Yes, sir. Your Honors, this case is about Congress using its constitutionally granted authority to enact legislation to protect individuals and institutions from unconstitutional religious discrimination. This Court should reverse the decision of the Court of Appeals for the 14th Circuit because Section 2 of the Religious Land Use and Institutionalized Persons Act, or RLUIPA, is constitutional under both Section 5 of the 14th Amendment and the Establishment Clause of the First Amendment. Moving to the 14th Amendment issue, RLUIPA is a valid and constitutional exercise of Congress's Section 5 enforcement power under the 14th Amendment for 2 reasons. First, RLUIPA is simply a codification of this Court's precedent, and second, RLUIPA is a congruent and proportional means to remedy unconstitutional religious discrimination, and therefore is in accord with the test set forth by this Court in City of Bernie versus Flores. Your Honors, RLUIPA simply codifies this Court's precedent. This Court held in Employment Division versus Smith that whereas neutral laws of general applicability should not trigger strict scrutiny, laws that substantially burden the free exercise of religion under a system of individualized assessments should trigger strict scrutiny. And that is precisely what RLUIPA does. RLUIPA mandates the application of strict scrutiny on the free exercise of religion is substantially burdened under a system of individualized assessments. And the policy behind this rule...
Counselor, doesn't the statute expand the notion of substantial burden, though, to all land use decisions, and our precedents didn't do that? Isn't Congress really usurping the judicial function by expanding the definition beyond the First Amendment?
No, Your Honor, and indeed the precise definition of substantial burden under the RLUIPA statute has not been clarified by this Court and is not certain. However, certain definitions have developed, and there is quite a high burden to show for a plaintiff to establish that there has been a substantial burden. And more importantly, the notion of individualized assessments does codify this Court's precedent because individualized assessments are subjective evaluations which allow for veiled or covert religious discrimination. For example, in Church of Lukumi Babalaway versus City of Hialeah,